So I think that California legislation should provide interpretive guidance. General statements of legislative intent may or may not be helpful. Why? Well, first, they're of limited value to the courts, basically aids in interpretation. For example, a recent California appellate court decision said legislative findings and statements of purpose in a statute's preamble can be illuminating if a statute is ambiguous. But a preamble is not binding in the interpretation of the statute. Moreover, the preamble may not overturn the statute's language. In other words, there first must be ambiguity in the statutory language in order for a court to refer to intent statements. Assuming there is, the second problem is that these intent statements rarely shed light on how to properly interpret the ambiguous language. If these legislative statements are going to be utilized by the courts as an aid in construing a statute, then these statements should be directed at the actual statutory language. This leads me to my proposal to include interpretive guidance in California legislative documents so that the courts do not have to try and use generalized intent statements to try and ascertain what ambiguous statutory language actually means. So let's start with an example of the problem and how my solution would work. For example, a bill is proposed to create a tax credit for hiring disadvantaged workers. Normally might include an intent statement like, it's the intent of the legislature to assist workers facing barriers to employment by offering a tax credit to businesses for hiring these types of individuals. Now, intent statements might also include some relevant statistics about limited hiring opportunities for disadvantaged workers, such as ex felons, etc. Now, the problem that I have seen is that we already know what the intent is behind such a bill proposal. In other words, how helpful are those intent statements really to aiding statutory interpretation? I would suggest that they are not of particular value. A legal dispute, such as between a taxpayer and the taxing agency, is not going to benefit from those generalized statements of intent. And a court trying to resolve the dispute between the taxpayer and the taxing agency will not likely benefit from those intent statements either. Why? Because a legal dispute involving the hypothetical tax credit is going to be over issues such as, is the taxpayer entitled to claim the credit? Did the individual hired qualify under one of the specified categories of worker? Understanding why specific statutory language was not or was chosen for this tax credit probably will not hinge on why the tax credit was created. Rather, the issues giving rise to a legal dispute would probably be, for example, again, whether a particular business could claim the tax credit or whether a particular worker qualified the business to claim the tax credit. So, again, how do generalized statements of intent assist a court of law in interpreting possibly ambiguous statutory language? From my perspective, they probably do not. From my perspective, in my opinion, these generalized statements of intent really don't serve as an aid to the courts or to executive branch agencies in interpreting the legislature's enacted statutory language. So, what do I suggest? I think California legislation in bill analyses, for example, or perhaps even in legislation itself, that interpretive guidance be included. What does this actually mean? And how would it look? Legislative committee analyses would include a sentence or two to explain the provisions of the bill that are adding new code sections or amending existing code sections. The purpose of this sentence or two would be a brief explanation of what is intended with these new or changed statutory provisions. For example, the legislature intends that these types of specified businesses qualify for the hiring tax credit, but not these specified businesses. Or the legislature considered including all felons as a qualifying category for this hiring credit, but decided that it is only for felons convicted under specified circumstances. Yes, I know this would require lots more work for committee consultants, and it would require active engagement and discussion among the committee's legislative members. But that could be accomplished if there were a sizable reduction in the bill introduction limits in the California legislature, and if legislative committees took on the role with a vastly reduced quantity of bills considered at their hearings of actually reviewing and debating the proposed statutory language contained in bills.